Mr. Savastano. Good morning.
Chief Justice Marshall, members of the court, good morning. My name is Anthony Savastano. I represent the appellant, the Standard Times Publishing Company. This case is an extremely important case of first impression in Massachusetts, and it has implications as to the constitutional rights regarding the freedom of the press and the public to access to jury lists.
Now, you say you want the jurors' names not to ask them about deliberations, but you also say you want the names so that you can ask the jurors what was said in the jury room. Isn't that access for purpose of inquiring into deliberations?
I don't recall that that was specifically what I said, Your Honor. However,
Thought that
the
was
judge
in the
can
brief.
certainly
Well, what do you want to
tailor-
ask them? What if you get to
Well, the
talk-
first thing we're concerned about, which is one of the clear reasons for allowing access, is was there a miscarriage of justice?
No, but you can't ask a juror, was there a miscarriage
Well,
of justice? What are you going to ask them?
We're going to ask them was about the reasons for the not guilty, and
That's going
was
into
there...
jury deliberations. You're asking them what went into their deliberations in the jury room.
I thought you could ask them
Exactly.
that.
I respectfully disagree. You cannot ask them what was said between jurors in the jury room, but you can ask them about their overall impressions of the trial. And there is a grave concern in this particular case that perhaps there was a not guilty because, based on one of the jurors...
You're not limited. I'm confused here. The press isn't limited in what questions they can ask jurors, are they?
No, and we...
But then we're going to violate the
The only reason
secrecy
we
of the
tried
jury
to
room.
suggest that the only thing we suggested, I believe, at the lower level was we talked about how we would identify the jurors in the press, in the newspaper. And that was, my understanding was the issue of the limitations the judge was concerned about at the lower court, not the juror deliberation issue.
Is there any case that says is there any case that says the press can't ask the jurors or juror what was said in the jury room?
No, instead, there are cases and recent cases out of the First Circuit Court and also the District Court, Judge Young
most
and Doherty,
judges-
where Judge Young expressed concerns about that, and he said, I will tailor a narrow, limited remedy, which is to instruct the jurors not to discuss it.
Well,
There's
that's
no
what- that's what
limitations on the
that's what
press
we always
asking
used
that
to tell
question.
the jurors, don't, you're
Mr.
not
Sav-
bound by this, but don't talk to the press about this. And then they go
Exactly.
ahead and do it anyway.
And I don't even think that was an issue in this case.
Mr.
I think-
Savastano, if that's not an issue, it's very important that I understand the answer to the following question, okay? I am looking at Judge Nickerson's order, and on page 3 of his order, he says, your client seeks the names and addresses of the jurors in this case, quote, so that reporters may contact the jurors to question them as to their deliberations, unquote. Is that statement correct or incorrect?
I believe we asked for the names and addresses of jurors without limitation.
Did you
as to what we were
challenge
going to
that
question.
aspect of his ruling on appeal?
I don't think he ruled that. I think the only thing
I've just
he...
read you from his ruling.
And that's the same question that I asked you. That's where I got that he says you said you wanted it to have access.
It's not a ruling, it's a finding of fact.
Well,
That
that's
your
why-
reporter's going to ask about deliberation.
That's why I asked if you had challenged that aspect of his
No,
order.
but because that wasn't part of his decision in denying it. The only
It
the only
is- I've just read
justification...
it from you.
I'm sorry?
It is part of his decision.
Chief, what
It's
page is
not
that
of the
on?
It's not
Page 3.
part of the reasoning for his denial. His only reason for
Where did
denial
that-
was
where
based
did
on
that
concerns
come
for
from?
juror safety.
Where did that come from?
I do not know where that came from. I don't
mean,
recall
is
that
it
ever being
anywhere in-
discussed.
Do we have a transcript of the oral argument on this motion?
It is attached, yes. It is in the record
there?
appendix.
Did he say, why does the reporter want to do this? And somebody like you or somebody else say, well, he wants to talk to him about what they said in the deliberations? We won't find it there?
I can honestly tell the court that I did read over the transcript over the weekend. I do not recall that. I was the one that made the argument, not the reporter.
No,
I do
that.
not recall that ever being discussed, and I certainly don't recall the judge ever expressing concerns about that.
But
His-
isn't that almost common sense of what a reporter would want to ask a jury? Why would
Certainly.
He wouldn't just call him up and say, well, I want to talk to you about whether you enjoyed your jury duty and what you had for lunch. He's going to say, what'd you say in the jury room?
Well, no, I think it can go both ways. I think he can ask about that, but I also think he can ask each juror about their individual impressions, which led them to vote not guilty. And I think there is a distinction between
Isn't
the
that going to change our
two.
whole system? We've always said that we don't want made public what went on in the jury room.
I think this decision, if upheld, will change our whole system because there is an historic tradition of openness
There is
and
not
access
Openness
to
in the
juror
trial.
identities.
There's openness in the trial. There is a historic tradition of closed jury proceedings.
We are not looking to obtain the details of what took place within the jury room. And
Well,
that is the
what are
distinction
you-
of this case.
okay.
We're only looking for juror identities, and I respectfully disagree because the First Circuit and every First Circuit that looked at this case, including ours, and every circuit court that looked at this case, including ours, the First Circuit, Hurley, has unequivocally said there is an open tradition, a history of openness
It
in
seems to me
the
it's-
identity
issue
of the
juror
jurors.
safety, because that
Yeah.
does seem to me to be what Judge Nickerson based his ruling on. And it seems to me that on the record before him, he had a very legitimate concern about juror safety, and he asked whether your client would accept a condition on the release, namely that they not publish any names or addresses, and your client
Said no.
said
That's right.
no. That was their practice, but they would not agree with having such a condition in the order. It seems to me at that point, he's confronted with the possibility that names will in fact be released, and that it would endanger this jury and have a chilling effect on juries in the future. What's wrong with that reasoning?
That reasoning is based on pure speculation. He did
It's
not
based on
held an
two
evidentiary hearing.
Well, that's a
He
different
did-
issue. That's a different issue. But just, let's assume that the police reports that he obviously received, correct? He
Yes.
received police reports. Police reports of fairly violent conduct associated with the outcome of this trial. Let's assume that we have an evidentiary hearing and the police officer testifies, yes, this is in fact what the underlying. And your client says, absolutely not. I want the juror names, and I will choose to do with them just what I want to do. I can publish them. I can interview them. I'm not going to agree to be bound by any questions about what went on in the jury room. I have a total First Amendment right. I don't care about anything else.
First
Is
of
that
all,
the-
as
is
Your
that the
Honor knows,
position?
in Harold v. Sharp, you stated that the court should frame a very narrow remedy. I don't have to agree with the trial judge, but if the trial judge was concerned about that, he could have framed a more narrow remedy, allowing us access with a specific order that we do not publish the
It is
names.
much more helpful to have parties try to help the judge fashion a remedy in light of legitimate concerns. If
And
you
we did
said-
that in our amended memorandum where we specifically stated unequivocally, and that is part of the record, that we would not publish the names of the jurors. We went the second step in the supplemental memorandum, which is part of the record appendix. But I'd like to talk about the police report and his speculative findings, because he talks about a shooting that occurs after the trial where bullets are fired into the
Hours
house.
Hours
Two
after
hours
the trial.
after
The
trial.
bullets are fired into the house of the mother of the defendant, where the defendant had admittedly not lived for 3 years. And if you look at the police reports, because he doesn't discuss them, but they are part of the record appendix, there's a gentleman by the name of Ryan Spinner who's standing outside of that house. The bullet passes through his jacket and somehow inexplicably through his shirt, but doesn't cause him harm. It's more likely, and this would have been brought out in an evidentiary hearing, it's more likely that he was the target of the shooting because he's a gang-related
all
member,
part-
as opposed to some unclear nexus to a not guilty
That seems
verdict.
to
There's
be-
no evidence to connect this shooting to the jury.
But it
jury
just
verdict.
happens to be 2 hours after the verdict in front of the mother's house.
It also, further separating that from the jurors, it is violence that is surrounding the members of these alleged gangs. It has nothing to do with the juries. There's no threats.
Mr.
The
Savage.
defendant has
A reasonable inference is that this verdict is not going to sit well with the gangs involved in the violence that led to the murder. The defendant got off. The other gang not going to be happy. Isn't it go right to the point that this is not over?
The nexus, I think, is really important for this court to understand the genesis of this case. The reporter, the judge did not express such concern that he issued a sua sponte impoundment order. It was only on second thought. The clerk was asked for the jury list by the reporter, which is standard practice, and typically they give it. And if they don't give it, they call me and I make a call and they give it. And that happened the year prior. But the clerk in this case had asked the judge. So the reporter asked the judge. And the judge said, oh, let me think about this. File a motion. Then only after hearing on the motion did he impound the jury list. This wasn't a grave concern. This wasn't a case that had intense media scrutiny. He talks in his decision about when the jury came down, the courthouse was empty. There was no one left but the participants and a lone
And the
reporter
people.
standing
They were
in the
all
dark
busy
by the
speaking
back door. There wasn't gang members nearby. There wasn't police
They were
security.
all busy doing
jurors
other things.
left on their own accord out the back door without any security. There was no concern for juror safety.
One juror asked to be excused because she was terrified for her own safety.
Before the trial and because
After
she
she'd
lived
been
in that
impaneled.
neighborhood.
After she'd been impaneled.
And started to hear it.
But-
I mean, the jurors express concern about their safety on a regular basis when they are involved in trials involving gangs or this kind of violence. It is a common fear, and one that trial judges work very, very hard to allay as best they can. They are concerned about it for the jury that's there. They're very concerned about it in terms of its ability to affect the fair empanelment of juries in the future. And it seems to me that Judge Nickerson is responding to a legitimate institutional concern that the court now has, namely that jurors who hear about these random, horrific acts of violence by people who are perfectly capable of shooting them, or the
Anybody.
prosecutor, or the judge, that they have fears that are not irrational and need to be addressed. They are given assurances about confidentiality, and the last thing they want is to see their name published in the newspaper as having been a juror on a case that is now a matter of some controversy.
I agree with you that juror safety is a legitimate concern. I disagree that they're given representations that they would remain anonymous. I think it's quite to the contrary, as clearly pointed out in the briefs. I do believe there needs to be a balancing test. I'm not saying it's unequivocally the jury list should be always disclosed at all times, but the courts have consistently said that the need for juror anonymity certainly decreases, if not goes away, at the conclusion of the trial, and the judge can frame a more narrowly tailored order, such as holding the list for 7 days. And I also think that it's clear that this judge was required to hold an evidentiary hearing to make some determination if there was any nexus
Why?
between these
Did you ask for
Why?
an evidentiary hearing?
He'd just been the trial judge. He'd heard about everything involved in this case. He had grave concerns about that. He put that right in
The
his...
two shootings he relied on were not part of the trial.
Mr.
And
Savas-
certainly
But
if
the trial was the background in which he evaluated these police reports about shootings.
Right, but
For instance, the attempt to kill the Commonwealth's lead witness.
And she said, if you look at the police report, she said in that police report, she had no idea who the shooter was. She didn't even tie the shooting, and there's no evidence, there should have been at least some evidence presented, that the defendant knew she was going to testify.
Savas-
We don't even know he knew she was going to testify to justify the threat. And if there was a
Mr.
threat that was
Savastano?
connected, then I think it would have been
Mr.
brought into evidence in the
Savastano,
case.
let me ask you this question. You have just recognized, I believe, that jurors' concerns for their safeties is legitimate.
Yes.
We cannot have evidentiary hearings about whether or not their concerns are legitimate. If there's an institutional problem, it may be in certain kinds of trials where the issue arises. In other words, it happens to be in this case there were some police reported incidents immediately following the trial. But it seems to me that if we are trying to fashion a rule, one of the rules we're not going to fashion is that you have to have an evidentiary hearing in each case as to whether or not any expressed concern is legitimate or not, because you undermine the whole point of ordering, by the way. Jurors don't serve because they feel like serving. They serve because they are ordered to serve. It is a great civic duty, but they are ordered to serve, and if they don't respond to a summons, there are severe penalties.
Your Honor, I'm gravely concerned over the slippery slope this could lead to. We're talking about first juror anonymity, then perhaps witness anonymity.
No, we're not talking about witness
Well, it could-
anonymity.
it
We are
could-
talking about juror anonymity. We are not talking about witness anonymity. We are not talking about closing proceedings. We are not talking about judges being behind masks. We are talking about juror anonymity.
And that is an unusual and contrary to the understanding of a trial by the peers, your peers in the community.
Well, if you believe that you should be able to interview the jurors, why then shouldn't you be able to interview the judge?
In a bench trial.
Or even in this type of a trial, why shouldn't you be
Because
able to
I
interview
have
the
not
judge?
looked at that issue, and I don't know whether or not there is an historic tradition of openness as to a discussion of with the judge. And the judge can certainly,
is
as
not
a
a-
juror can, the judge can certainly say, no, I don't wish to be
But
interviewed.
there has not been a historic tradition of interviewing the jurors. And what if you did find out that there were outside influences such as fear or concern of the jurors for their own safety? The defendant can't be retried, so what if you learned that the jurors were in fear of their safety? So what? What can you do?
I'm sorry, I don't understand the question.
If you said in answer to one of my first questions that what you wanted to find out was if the jurors voted the way they did because of fear for their safety. Suppose you find that out.
It certainly
can you
could
do? The defendant has been
it certainly
acquitted.
could expose flaws in the system, which is one of the reasons the principle of openness is designed to expose flaws in the system and allow the system to correct itself.
I don't see how the fear of the jurors for their safety is a flaw in the system.
One way to make sure that jurors are made more afraid is for them to be told, which they would have to be told at the beginning of a trial, and by the way, we cannot keep your names confidential. If you want to think of corrective measures.
Well, we'll wrestle it out.
Thank you for your time.
Thank you, Mr. Savastano. Mr. Zeman?
May it please the Court, Randall Ravitz on behalf of the Bristol Superior Court. The Superior Court did not abuse its discretion or act contrary to law in refusing to disclose the names of jurors who served in a criminal trial that was surrounded by a particular amount of violence.
Let me ask you about what you just said, refusing to disclose the names of jurors. In your brief, I think you cited Chapter 234A, Section 23, which talks about the questionnaires of the jurors selected as not being public records. Is the list of the jurors who were called in the venire still in existence?
My understanding is that normally that type of list will be maintained in the case file without the addresses.
The list of all 150 or
Oh.
250 people that were summoned in for jury duty?
Oh, I'm sorry. I thought Your Honor
No,
was
no,
talking
no.
about-
I'm trying to figure out where the names are coming from. Are they going to come from the questionnaires, or are they going to come from the list that was summoned in?
As far as the list of those who are summoned to appear in a given day, everyone, that can be accessed by a member of the public unless the court orders otherwise, under a separate statute that we cited in our brief.
But that's not, they have not sought access to that list. The newspaper has not sought access to that list.
There's nothing in the record to indicate that they have.
They're looking for the questionnaires?
They're looking for the names and addresses of the jurors.
Where is
which
that written down?
My understanding is that it is common for there to be a separate list of the names of jurors, but not necessarily the addresses.
Isn't there in the folder in the clerk's
In-
office somewhere there's a list of the jurors in that case, just their names but not their
Yes,
addresses?
yes. As a document that's separate from the questionnaires.
Even if there isn't, they're easily identifiable because you've got the numbers, which you can relate to the names originally, correct? I mean, you bring down, you pick number 12, number 22, so on. Well, you then can go back and say that corresponds to, the list.
If one had the right kind of information, they could do that.
If we were to say that this list of jurors that's written down is effectively the same as the questionnaires for purposes of 234A, Section 23, isn't that the end of the case?
That would be, yes. And there is one state case, not from this Commonwealth, but from New York, where the New York Court of Appeals found just that the confidential juror questionnaires there, the confidentiality of the questionnaires protected the confidentiality of any information that was listed in the questionnaires.
Mr. Zeman, I didn't have a chance to ask Mr. Savastano yet, but I take it you've had an opportunity, or have you had an opportunity to read the amicus brief filed by the Newspaper Publishers Association?
Yes, Your Honor.
They mention a number of briefs, a number of cases. Is there any case, to your knowledge, where the a court has ruled that under the First Amendment, not as a matter of statutory or common law, a newspaper has a right in a criminal case to have the names and addresses of jurors.
I believe in the Antar case out of the Third Circuit, the court did recognize such a right.
With or without limitations?
That I don't recall.
Did the Commonwealth take, in this case, did the Commonwealth take the position that if, well, the Commonwealth opposed the motion when it was brought, correct?
The district attorney's office did not formally oppose it, but they did make comments in the hearing discussing the dangers that could arise from releasing this information.
Did the Commonwealth take a position as to whether or not the jurors' names could be disclosed to the Standard Times based on certain limitations, such as that the names would not be published?
They didn't take that position.
To your knowledge, did the Standard Times ask for access for purposes other than inquiring into juror deliberations?
I can't speak for the Standard Times intent, but I can state, and this responds to questions that were raised to my brother. The reporter, Raymond Henry, who first requested the information, stated that he wanted to interview the jurors about their decision. And Mr. Stavastano stated at the hearing that they wanted to determine if there was any juror bias or just what their thought process was. And I point that out because it's that thought process that's entitled to a particularly high degree of protection. Not even a judge can inquire into a juror's thought process.
but
But
not
it
even
happens all the time, doesn't it, that a newspaper reporter will be waiting outside the courtroom when the jurors come out, and they can talk to the jurors about anything they want to. And if the juror answers the question, it appears in the newspaper, doesn't it, including their thought process?
That's correct, and that can happen. But the issue here is to what extent the court is obligated to facilitate that process, to provide them with that information. And there's a distinction drawn in the case law between those two things, between whether someone has a right to interview jurors or to comment on proceedings, and to what extent the government has to help them.
Isn't this all irrelevant? Isn't the bottom line here, if the judge, and I think he perhaps did, made adequate findings and rulings that there was a big issue of safety about these jurors, identities, if they were approached and their names were made public, which of course the reporter said he would not agree to keep them non-public. Doesn't that sort of trump everything and allow the judge to do what he did? So that we don't have to worry about, does the statute cover it or not cover it? Does the, what did the reporter want to talk to him about? Though it appears apparent he wanted to talk about their actual deliberations and so on. Safety. I mean, this is a vicious killing. The guy got acquitted. 2 hours later, the mother's house gets shot at. Somebody else almost gets killed. Right?
Yes, we would argue that no matter what test is applied and no matter what the extent of the constitutional rights are, that in this particular case, where the judge made findings and was motivated by, as Your Honor said, a concern about safety, and it wasn't even just a concern that jurors might have fears about their safety. It was a finding that any such fears would be justified, that there really was a danger to
One of them
their
got off
safety.
the jury because of that. One of them.
That's correct.
If this list that we're talking about is actually protected, if we say that it's protected under Chapter 234A, section, or if it falls within Chapter 234A, Section 23, it's not a public record, and the judge wouldn't even have to make findings for purposes of impoundment, would he?
The judge would have to make findings if it were found to be protected by the common law principle of publicity.
Wait a minute, but there's a statute that says that they are not a public record. If that's Doesn't that statute trump the common law?
The statute could certainly trump that common law principle, and there are other examples of that where documents are maintained as confidential pursuant to statute. The questionnaires themselves is an example.
Mr. Ravitz, I have a procedural question for you. The newspaper didn't file a motion to intervene in this case. Should they have?
Well, we have to concede that this Court has said that in the criminal context, a motion to intervene is not absolutely necessary because the rules of impoundment procedure are not binding. If, as my brother suggests, this were construed as a civil proceeding, then in fact they would have had to move to intervene.
This was a criminal case. It
That's
was a
right.
murder case.
That's right.
So you concede they didn't have to
That's
file
right.
a motion. So
Right.
you agree they did not have to file
That's
a
right.
motion to intervene.
That's right.
Isn't there a statute, I'm looking at 234A, Section 67, that says a list of the jurors, trial jurors, who appear for service has to be kept, and unless the court orders otherwise, that list is available to members of the public.
But
Right.
that's the 250 people or whoever many that are summoned in at the beginning of the day.
That's right. And notably, even that, as Your Honor said, allows for the names not to be disclosed if a court orders otherwise. And
unless
there's
the
no
court orders.
particularly high standard written into the statute. It just says if a court orders otherwise.
Do you have any authority from other jurisdictions that supports the non-disclosure of the identity of jurors?
Yes, Your Honor. In the Fifth Circuit, there have been a number of cases. There's United States versus Edwards and United States versus Brown are two recent Fifth Circuit cases. I mentioned earlier a case from the New York Court of Appeals, and that is Newsday versus Seiss.
These are all in your brief.
Those were not. We focused on state law and binding precedent in our
What about-
brief.
Why don't you give us those other ones, too? Send them in.
We can
Just
certainly
send
do
them a
that.
letter with a
A
copy
letter
to
with
Mr.
copy to Mr.
Savastano.
Absolutely. There's also a Southern District of Texas case. And even in those cases cited by the Standard Times and the amicus, where courts did ultimately turn over the list of names of jurors, generally speaking, they recognized that there could be situations, particularly involving threats to juror safety, where such disclosure would not be appropriate. And so in a case like this, even those cases that are least favorable to our position don't seem to apply to this particular situation.
Well, how is the judge supposed to make that determination? The newspaper said in this case there really should have been some form of evidentiary hearing. Why isn't that appropriate?
We're not aware of any binding authority that required an evidentiary hearing. But in addition to that, in this particular case,
Did they request one?
there's nothing in the record that indicates that they requested specifically an evidentiary hearing.
Well, isn't that the end of that?
I would think that would resolve that. But
There
even
was
if
a
it
hearing.
didn't,
There was a hearing.
yes,
And then the judge asked the Commonwealth to send him or submit to him the police reports about the incidents that the Commonwealth had
That's
mentioned.
right.
And then the court just issued its decision.
that's right. And the judge in this case,
But if an impoundment procedure applies, there has to be an evidentiary hearing.
there has to be a hearing and there have to be findings. The rules don't specifically state an evidentiary hearing. And
How do you make findings?
Well, in this particular case, I think that there could be certain situations where maybe an evidentiary hearing would be necessary. Not because it's required, but just as a practical matter.
You're saying that the police reports were sufficient based on the fact that this is right on the heels of the trial, the judge could take into consideration his experience from the trial, read the police reports, and issue findings.
That's right, especially in a case like this where it's particularly based on the judge's own observations during the trial. It's very similar to a judge's order of sanctions, which like this is tied to the judge's inherent authority to control his proceedings.
What would an evidentiary hearing be? It's already been said we're not going to bring jurors back and grill them over whether they'd be afraid or not. You certainly can't, grill a reporter over what are you going to ask. I want to know what the questions are.
Right.
So what would this hearing be, this evidentiary hearing?
I can't imagine that it would perform any useful purpose.
Well, Mr. Savastano,
Well, and
I
here
think-
it could have formed the purpose of having further explanation, or about the police reports, further details on these incidents, having nothing to do with the jurors themselves, but whether there was objective facts that would support a conclusion that there might be some danger.
I think maybe
But then you might, if these are pending matters, you might get in the way of an ongoing criminal investigation. If you start bringing in the police who are investigating this shooting that took place 2 hours after the verdict was entered.
Maybe I missed it. Did Standard Times request an evidentiary hearing?
there's nothing in the record to suggest that they requested specifically an evidentiary hearing. But even if it could have served some purpose, such a hearing would not have been necessary here. It's also the case that here, perhaps the person that we'd most like to hear from is the shooter. And of course, that person wasn't caught, but that's even more of a reason to keep the names confidential, because we know that at least one person is still out there, and we can only infer what his or her motives were in firing upon the house 2 hours after the verdict and in firing upon a key witness. Actually, it was probably the other gang that fired upon the key witness.
John Grisham wrote a book about this kind of stuff, didn't he?
Probably did.
Well, he did. I read it. Where they intimidated the jury with this kind of stuff.
Runaway jury.
I thought it was the juror. He's got so many books. Well, anyway.
Thank you, Mr. Levitt.
Thank you,
If
Your Honor.
have nothing further. Thank you. We'll take a short break.
All rise.